Welcome to the Tenant Law Podcast, where all types of New York City tenants can learn about the laws that affect their apartments. Rent-stabilized tenants, free market tenants, good cause tenants, luxury tenants, loft law tenants, co-op shareholders, subletters, roommates, co-livers. Let's all learn to live better. Welcome to the Tenant Law Podcast, where we talk about new, interesting, and/or important legal cases, laws, and topics affecting New York City tenants. I am Michelle Itkowitz, and today we are discussing a recent eviction case that was dismissed when the tenant pointed out to the judge that the landlord lacked capacity to sue because of the defunct status of its limited liability company, which is an easy thing for anyone to look up regarding their landlord. First, let's set the stage with some context. Most New York City multifamily real estate is owned by entities. Individual people do not own big buildings, big apartment buildings, for all kinds of legal and financial reasons. Rather, apartment buildings are almost always owned in New York City by limited liability companies, LLCs. An LLC is a form of business entity, just like a corporation is a form of business entity. A limited liability company is sort of a hybrid business entity combining the tax aspects of partnership with the limited liability of a corporation. LLCs in New York are governed by the New York Limited Liability Company Law. In order for an LLC in New York to be set up, the law requires the members of the LLC. Remember, LLCs have members, whereas corporations have shareholders, but it's really the same thing. So in order to set this up, the members have to do a whole bunch of things, and one of those is to follow Limited Liability Company Law, Section 206A. That's what this case is about today. 206A tells us that the members of the LLC, within 6 months of the date of the effectiveness of the initial articles of organization, they have to take those articles of organization and tell the whole world about them in the following way. They have to publish the articles of organization for 6 successive weeks, 6 weeks in a row, and they have to publish it in 2 newspapers in the county in which the office of the limited liability company is located. So one newspaper that will be printed weekly and one newspaper that will be printed daily is where they have to publish it. 2 newspapers, 6 weeks in a row. And once they're done with that, they have to get an affidavit showing that that publication happened. And they have to file the affidavit with the state. Now, that sounds like a huge, expensive pain in the backside, and it is. There are actually services that will do this work for people setting up LLCs. There's a similar thing for corporations. So there's these services. And for a fee, they will do all this publishing. Now, why am I telling you all this? Here is the important point to set the stage for today's case. Limited Liability Company Law, Section 206A, also goes on to state that if proof of publication is not filed in a timely fashion, then the authority of the limited liability company to carry on, conduct, or transact any business in this state shall be suspended. The company is suspended and can't do any more business if it doesn't live up to this publication requirement. So I think you see where we are going with today's case. Today's case is called Hull Unique Equities, LLC versus Boone. It's a housing court case from Brooklyn, Kings County, in the fall of 2024, so very recent at the time I'm doing this recording. I'll put a link to the case, as always, in the show notes. In today's case, a landlord sued a residential tenant. And the tenant asserted the defense that the LLC landlord petitioner did not comply with limited liability company law 206A. They did not do their publishing, and they were suspended by the state from doing business. First, let us talk about how the tenant or the tenant's attorney would even know that the LLC was suspended and failed to comply with the law. How would they know that? The case doesn't tell us, but probably the tenant knew because any member of the public can easily look up any corporation or LLC and see if it's in good standing in New York State by looking at the New York State Department of State Division of Corporations website. I'm going to put a link to that in the show notes. It's a very simple, easy-to-use portal. You just type in the name of the entity, and it tells you if the entity status is active or inactive. If the status is not active, the entity is not eligible under New York law to sue people for rent. By the way, we're talking about LLCs today, but there are analogous laws for corporations if your landlord is a corporation. And there are other things that both LLCs and corporations can do wrong to lose their ability to sue anybody. For example, if the LLC or the corporation fails to pay tax to the state for long enough, the state will just automatically deactivate the company. They will suspend them. The bottom line is that for an LLC or a corporation to sue someone in New York, including a landlord entity suing a tenant, that corporation or LLC needs to be in good standing with Albany. In today's case, the landlord pointed out that there is authoritative case law that says that when a tenant raises such a defense, that the case should not get dismissed, but rather the case should be put on hold and the landlord should have some time to cure the defect of not being in good standing, and then the case can start up again. So that's the defense the landlord asserted. In today's case, however, the judge noted that although the landlord was pointing out that there's case law that said the landlord could cure, that this particular landlord was not submitting any evidence or even a suggestion that it was trying to cure. So the judge dismissed the case. Even if this judge did not dismiss the case, it would still be bad for the landlord here. And here's why, and this is important. For one thing, the law the landlord failed to comply with requires 6 weeks of publishing, 6 consecutive weeks of publishing. So even if the landlord paid the hefty fee to someone, some corporate services vendor, and started the process of publishing, it's still 6 weeks of publishing. So by the time they hire somebody and they file the affidavits, you're looking at least 2 months of delay while that whole process plays out. Now, that in and of itself brings up some very important tenant takeaways, but first, let's get the housekeeping out of the way. This is not legal advice. I am not your lawyer, but because I am a lawyer, this might be considered legal advertising. If this is legal advertising, it is terrible legal advertising because I'm asking you not to contact me. This pod is not a commercial for me or my law firm. This is simply the podcast that I always wanted to make. Let us know what topics you would like to hear more about, and if you deem this work worthy, please bestow upon us the 5 stars and do us the honor of subscribing. I'm told that subscribing is really how the podcast gets to more people, so please subscribe. And it's time for the tenant takeaway. Tenant takeaway time. As I record this, it's Christmas. It's also Hanukkah. And I'm going to segue into the tenant takeaway after I take one little minute to talk about why I started the podcast and how I hope it's helpful. And it's not just me talking about me. It segues into the takeaway today. 2 years ago in the spring, I signed up for one of those very cheap podcasting apps. I wanted to do a podcast about commercial lease guarantees, and I still might. But I decided to practice first with material that would be interesting to residential tenants because so much of that stuff comes across my desk and it's part of my work. I wanted to practice with the podcasting technology and I wanted to find my podcasting voice. I grabbed 5 recent interesting residential cases and I realized that podcasting was harder than I thought it was going to be. At that point, the app I had signed up with, which was like podcasting for dummies, was purchased by Spotify. So then I had to learn the Spotify stuff. And then Spotify started collaborating with Riverside FM for its creator tool. So I had to learn Riverside. And I like Spotify and Riverside very much. But for me, there was a learning curve because I'm all alone doing this. And after the first 5 episodes, it didn't seem like many people were listening, and I wasn't doing anything to promote it. Like I did nothing. I didn't even tell anybody I was doing it. I did no social media, didn't spend a dime. I just recorded the 5 episodes and put them up. But I committed in my mind to doing 6 episodes because I heard that means you're a real podcaster if you get to episode 6. So I did the 6th episode. I put it up at like 1 o'clock in the morning on a Sunday night. And the next day by 10 a.m., I noticed that 34 people had listened to episode 6 at some point between 1 a.m. and 10 a.m. And I'm like, wow, I know I'm not giving Joe Rogan a run for his money here, but who were these listeners? Where did they come from? So I did more episodes and more people listened, and the podcast took on a life of its own. Now, let me say a tiny bit about my law practice, which I've resisted doing here for almost 2 years. Half my practice is very high-level commercial cases. It's not unusual for me to work on a landlord-tenant case that has to do with an entire New York City office building. The other half of my practice is residential, and half of that is me representing residential tenants. On every episode of the show, as you just heard me do, I tell listeners not to call me and that this pod isn't a commercial for me. My prices are very high at this point in my career journey. I've been at this for 30 years in a very intensive way. So to put it in perspective, most people who found their way to me via the podcast are being sued for less money than I would require to be hired for a new case. So in other words, you'd spend more money hiring me than you would if you just paid your landlord. So I don't make any economic sense for the bulk of housing court cases. So if you're wondering what residential tenants are hiring me, it's people who either want to hold on to or get into a rental situation that's akin to an asset. So if you're fighting over a rent-stabilized apartment, which could be your forever home, or now I suppose that will expand to good cause eviction law protections, or if there's a dispute involving your proprietary lease and your co-op, those are people who, if they have the resources, find I make economic sense because I'm basically fighting to get them a lifelong housing situation at a controlled rent. The bottom line is, I'm a very tiny law firm doing impactful, bespoke work for people who can afford me. That's who I am. So this is obviously not a commercial because I'm saying don't contact me. I can't help most people. So what am I doing with this podcast? Why am I closing on 2 years in the spring? What pain am I trying to heal and for whom? Here's the thing. If you're indigent, God forbid, you at least have access to certain resources in New York City when it comes to your housing. If you economically qualify or if you're in the right zip code, you can get free legal aid to help you in housing court, although I know they're stretched very thin these days. And legal aid attorneys are the absolute best attorneys out there. And you can get assigned a social worker and you can get assistance like one-shot deals. Now, I fully understand that these systems are not perfect and these resources are strained to the breaking point at this point. And there are people falling through the cracks, but at least the safety net is in place, even if it has some holes in it. Then on the other end of the spectrum, if you have money, you will hire someone like me. But what if you are everybody else in the middle? What if you are most people? What if you're New York City's stressed out middle class and you're having landlord-tenant problems? I honestly don't know where you're supposed to go. But I see you. I see you. I see you in court when I'm there up in front of the judge by yourselves. And you call me, a single father in Tribeca, in the tech industry having trouble paying the rent who doesn't want to move because he needs stable housing for a custody battle he's in the middle of. Or a woman who's an independent filmmaker in Greenpoint whose income fluctuates because she's a creative, whose landlord is squeezing her, and she's not stabilized or good cause protected. A family in Cobble Hill who just doesn't want to move this year because their kid is applying to college in the fall, but they can't afford the rent hike they're getting from their landlord. I keep a log, and I get about 400 calls a year like this. And again, I'm one person in a private practice. So while everyone is welcome here, New York City's middle class has become my target audience. People who do not have access to a free lawyer or a one-shot deal, but they also don't have a rich daddy and a 7-figure salary. There's no safety net for most people as they grapple to remain middle class in New York City. I understand that I'm not going to solve New York City's terrible housing crisis with my low-budget, bi-weekly 15-minute podcast. I can't be everyone's lawyer, but I can be a teacher. I have 30 years of information rattling around in this brain, and if I can offer it in bits and pieces, and if I can learn to do that well enough via this podcast, and if I can help even one dad in Tribeca stave off eviction long enough to get his Christmas bonus, or one independent filmmaker in Greenpoint negotiate a better lease with her landlord, or if I can point you in the right direction to get your repairs done faster, or break your lease more easily, or take proactive steps to help support your housing situation in the future, if I can help a few people, then I'm happy. So about that, please listen to me carefully. We cover a lot of different things here on the Tenant Law Podcast, and in some of these episodes, like this one, are what we could call housing court hacks. Let's put them in perspective. And I've said this before, but I really want to emphasize it, and I thought this was the context to do it in. If you take one of these tools, like the one I've given you today, that you can get your case dismissed if your landlord's LLC or corporation is in bad standing in Albany, which you can find easily on a website. If you take that, call it trick, hack, and you merely get the case against you dismissed, and then you go home and wait for the next case, because it doesn't mean the rent's not due. It just means the case can't be brought until they fix it. Then you're not using the advantage optimally. All you've done is win a battle, but you haven't won the war, and the rent is still due. And the landlord can bring another case. I want to modify that. I want to take that back a little. If all you need is time and the landlord is not giving you time, then sometimes a trick that buys you time has great value. It has implicit value. Maybe you're trying to get the money, or maybe you need more time to move, or maybe you need more time for your kid to finish up in that school district before June. Okay, then time would be valuable. But if your agenda is not about buying a little time to achieve a goal, and you have something that you can use against your landlord, you need to use it strategically. So you could take your advantage and talk to the landlord or the attorney for the landlord, preferably, and in exchange for backing off from your advantage a little, you get yourself some concessions. You get more time to pay, or you get a bigger rent abatement, or you get more free rent and time to move. The landlord should settle with you for a better number or more time or whatever it is. If you use that advantage strategically, don't just beat your enemies over the head with your advantages. Use your leverage in a way that you can get some of the stuff that you need as well. Always be seeking a mutually beneficial solution. And there you have it. Remember, New York City, the law belongs to you, but your ownership of the law is only as great as your understanding of the law. So let's learn to live better. Merry Christmas, New York, and Hanukkah Sameach.